Hello, my name is Brandon Wells, and today we'll be going over Injury in Fact for Grand Canyon University CYB 220 with Mr. John Zupon. Data breaches are becoming increasingly common. In this presentation, we will view what is injury in fact, what requires it to be deemed as enforceable versus unenforceable, one case where it worked, one where it did not, and what is the company's or federal agency's responsibility if data breach happens. What is injury in fact? In order to introduce a lawsuit to a court, a plaintiff must be able to show Article 3 standing. The most important of this is called injury in fact, meaning there has to be a real and provable injury. It must be concrete, particularized, meaning how it impacts one person specifically, and an actual or imminent danger, meaning something must have happened or for sure will happen. In data breach cases, it can include topics such as financial impact, identity theft, and fraudulent charges. One case is Claridge versus Rock U. It is often cited when discussing injury in fact because courts ruled that the unauthorized exposure of personal data itself can lead to concrete injuries. Even without a monetary loss, the plaintiff's loss of control of their own personal data was enough to satisfy the injury in effect for the courts. And this helped others realize the value of personal data. One case where it did not work, however, was Amnesty International. Clapper versus Amnesty International in 2013. Amnesty International and a few others sued the government over a surveillance law that they feared that their communication with foreign clients might be monitored. They argued that there were costly security measures, they worried about being monitored, and their communications being intercepted. The courts ruled that since they could not prove injury in fact because it was too speculative. When a data breach occurs, companies must take charge to ensure proper measures are taken. They must notify those impacted by the leak, notify the proper authorities that there was one, investigate and fix how that leak occurred, as well as take reasonable steps to make sure that future harm is limited. Data breaches are becoming more and more increasingly common, and the courts are working to better identify what is versus is not appropriate use of injury in fact. Injury in fact requires concrete and real harm like that of Claridge versus Rock U, which shows how laws can be applied to the cyber world, while others such as Clapper versus Amnesty International prove that you cannot rely on possible future injury or hypothetical harm. Companies have obligations to their clientele to respond quickly, notify impacted individuals as well as the proper authorities, and then they need to fix where that leak came from in order to better ensure this does not happen again. And here are my references on the cases and what is injury in fact.